Good afternoon. This is Renee Townsend, and I'm here with my partner, Nate Edmonds.
Good afternoon.
We're here to talk about the sweeping changes to the No Fault Act that were just recently passed by the Michigan legislature and how those changes are going to impact insurers in the state of Michigan as we go forward with this law.
Well, this wonderful deal has been reached on Michigan no-fault reform. On May 24th, 2019, the Michigan legislature was able to pass this sweeping no-fault reform, and Governor Gretchen Whitmer has indicated that she will sign this bill. We are anticipating this week during the Michigan Mackinac Conference, and we will soon see it signed into law.
So a few of the reasons that no-fault reform has become such an issue in this state, as I'm sure most of you are aware, is really to combat the fraud that we've seen in a lot of our claims, provide options for coverage for Michigan residents, and to help to reduce what are the highest insurance rates in the country. This statute is going to come into effect for all policies that are effective after July of 2020. So everything we're going to talk about is about a year in the future, but you need to be prepared now and start thinking about this over the next year as to how these claims are going to be handled going forward.
Today we're going to address this as a general aspect, and then we will have different sessions where we break out the effect on the PIP and on the bodily injury claims. This is a whole new world for rewriting a law that was first written in 1973. In essence, they have rewritten the entire no-fault law with Senate Bill 1, as it's been commonly referred to. We can start off with the scoring of the credit can no longer be used, different factors. I don't think it has a whole lot to do with you as insurers or claims representatives, but the main thing is that when we talk about the rates, which is how the rates will be reduced, you can no longer use sex, marital status, home ownership, credit score. They can use a territory, which is, by the U.S. Census, approximately as small as 4,000 individuals. So there can be, similar to a postal zone, rating increases.
So the changes to the rating qualifications or the classifications were really the key factor for consumers in Michigan with regard to people in Detroit specifically feeling that they were charged too high of insurance rates. We saw that Dan Gilbert and Mayor Dugan really had a large impact in pushing this legislation forward because they were proposing their own ballot initiative. That was one of the key aspects of getting this deal passed. Another part of the increased oversight and consumer protections is what the Department of Insurance and Financial Services is going to have to put on their website just to make it more user-friendly for any insureds or consumers as to making complaints about insurance companies, being advised of their rights under the new No Fault Act. And they have the ability then to report fraud through their website. They have the ability to report issues they've been having with an insurer as to a claim being processed. So a big part of the bill was really put into place in order to try to assuage some of the concerns of Michigan consumers as to the no-fault insurance system.
The rate rollbacks we talked about briefly before we get into the PIP coverage options, these are good for 8 years. After 8 years, it's going to be up to the insurers to set their own rates, but there will be a 10% rollback for unlimited PIP, 20% for 500K, 35% for 250, 45% for 50K Medicaid PIP coverage plans, and 100% if you opt out completely. All right, let's get to what's important, the PIP coverage options. The unlimited lifetime medical is no longer mandatory. You can still choose it. Most people probably will not choose it because they will have to pay a large portion of the MCCA assessment fee that will be going forward. So most likely, most of insureds in Michigan will probably be selecting the 250 limit. You cannot get the 50K limit unless you have on Medicaid and your insured spouse or resident relative has qualified health care coverage or other auto insurance. This is key. I'm sure this will be an issue of contention is how to prove it. And if they don't have it or they lose it at some point in time, what happens? This option only reduces the premium by 45% or greater per vehicle as to PIP coverage only.
And as Nate said, the typical consumer is probably going to choose the $250,000 limit. It's the lowest limit that someone who's not on Medicaid can get. if they're going to opt for PIP coverage at all. This option requires a reduction in premium of at least 35% as to the PIP coverage premiums.
Next, we have the 500K limit, 20% per greater vehicle as to PIP coverage. This is probably going to be, I don't know why people would pick this option, because then you can also get unlimited coverage. So this may be as if you just want some additional coverage, but you're going to pay 15% more. So most of it's driven by economics.
And then you still have the option to have unlimited lifetime medical, but as Nate mentioned, it's probably going to be pretty expensive for the average consumer unless they have some concerns or fears about what would happen if they were in an accident. They really want to protect themselves in that way. It's only going to give you a 10% reduction in premium, but you will continue to be covered for unlimited lifetime medical, and that's when you would have the MCCA continue to step in at the retention.
Next, we have the PIP coverages when you have no PIP coverage elected. You may opt out, and this is where it looks like most of trying to get towards the poorer classification of individuals who lack auto insurance, possibly in rural areas as Detroit. They will not have any PIP coverage, but they must have health insurance and a deductible of $6,000 or less per individual, and you must obtain PIP coverage within 30 days if your health insurance is terminated. You have no premium for PIP, so that's going to be a 100% reduction in your PIP. As it relates to the MCCA assessment, we are assuming that those will be gradually reduced, phased out for these individuals as it begins in 2020.
The other kind of situation that the legislature accounted for is if somehow someone doesn't make an option selection. If no option is selected, there's a rebuttable presumption of the coverage level based on the premium amount paid. So if they fill out an application, they don't make that selection, but they're paying, $300 or $200, whatever the corresponding coverage level that typically is, that amount is typically charged for, will be the presumption of what they've got. It's a rebuttable presumption. If you're in kind of another situation where the no option is selected and no premiums have been paid at all, then they go and default into the unlimited lifetime medical option.
One big thing too is this also has an inseverability clause in the act, which means that if a court invalidates a rate rollback provision, the entire act is invalid. That means we would go back to what we had currently. So that is still to be seen if that's going to get challenged in court. I'm sure there'll be challenges to this act as we move along.
The new reform bill gives some direction as to persons who opt out of no-fault coverage and what kind of priority they would fall under if they were in other situations where no-fault coverage may be available to them. They're essentially entitled to PIP coverage under all other available policies pursuant to the priority rules, but if no other policies are available, they go to assigned claims. If two insurers are determined to be in the same order of priority, benefits are only payable up to an aggregate coverage limit that equals the highest available coverage limit under any one of the policies. So that's when we're getting into what limit was selected by the insured as to the 250, the 500, and then the two insurers in the same order of priority would have to meet that limit together.
One of the bigger issues is attendant care, as you well know. Well, they were able to cap the attendant care at 56 hours per week, which is the same number as the Workers' Compensation Act, and it is the home family friend provided attendant care aspect. Neurological rehab clinics are not entitled to payment for treatment unless it's accredited by the Commission of Accreditation and Rehabilitation Facilities or a similar organization. What is a similar organization? Well, that's going to be up to interpretation again. So yes, attendant care definitely will be affected by this, which is a great aspect. However, remember, all of these caps, they're still subject to being able to anything above it. You will see claims above it, and you can deny those claims that are above the act, and they are simply submitting them to build their BI case where they can claim these amounts in a bodily injury claim. That is why they'll still make claims for more of them, because if they just documented it at 56 hours per week as provided, then they may be barred by not making the claim. So you still may see higher claims coming in.
The other thing to know about attendant care in this new no-fault law is that insurers are being required to offer additional attendant care as a rider. So it's an optional rider that an insured can select to allow them to have attendant care in excess of the applicable limit for coverage. They would pay a higher premium for that, obviously.
We don't know what the rider will look like or what ultimately will be approved by language by the Department of Financial Services, so that is also up to interpretation.
The new No Fault Act calls for a managed care option, which is essentially optional coverage selected by an insured at the time that a policy is issued that allows the insurer to monitor and adjudicate the injured person's care, allows for a network of preferred providers to be utilized, or another similar option, which allows basically the injured party and the insurance company to come to an agreement from the very beginning, from the very inception of the policy, that if you're injured, you go into this managed care program. Discounts must be applied for that type agreement, but it will reduce costs for the insured. It will reduce costs, hopefully, for the insurer as well, if that option is selected.
The wonderful healthcare provider claims. Yes, what is going on with the provider suits? They are still viable. They have been codified, which means they are now allowable under the statute. They do have a direct cause of action, so we will no longer be arguing about that. The only aspect that we probably will be potentially arguing about is who's paying what, in what order, and what priority as it gets to when bills are presented. And you start getting to the limits of what the coverage is. That can be an issue. The providers, though, they will have the workers' compensation fee schedule, which will take that out of an issue for us. So even though they have a direct cause of action, they're going to be limited as to what they're able to claim.
And as Nate was talking about, one of the big issues that we've seen in no-fault litigation are the charges that are being presented by the no-fault medical providers. We know that they're often greatly inflated by hundreds and hundreds, if not thousands of dollars. That was one of the key issues that the insurance industry wanted to see reined in under the no-fault reform bill, and it was a pretty comprehensive plan was put into place, essentially making a fee schedule where for a period of time, medical providers rendering treatment between July 1st, 2021 and July 2nd, 2022 cannot be reimbursed more than 200% of the Medicare rate. That 200% decreases by 5% each year through 2023 until it reaches 190% of the Medicare rate. Certain facilities can make requests to allow higher rates to be charged. There are special rules dealing with how many indigent patients they accept, whether they're a freestanding rehab facility, and other pretty case-specific factors, including level 1 or 2 trauma centers having their own higher rates. So the statute calls for certain exclusions to this 200% of Medicare fee schedule, but most of the providers we're going to see are going to fall under that 200% fee schedule. If a treatment or service is not covered by Medicare, the provider, so we don't have a Medicare rate to go off of, the provider will be entitled to payment at a percentage of their applicable charge master. If they don't have a charge master, it'll be a percentage of the average amount the provider charged for the treatment at that applicable time. And an example given in the, or a standard given in the statute was 55% of their charge master prices.
You're going to see that a lot of compromise obviously was done in this bill, and you can see which providers carried more weight with the legislature by how they were considered in that fee schedule. All right, utilization reviews. This is going to be done by providers who render treatment that are related to the PIP claims. They agree to submit their records and information concerning treatment for utilization and comply with any decisions of the Department of Insurance Financial Services under the Act. So obviously you can see that now we've talked about DIFS on several occasions. This office is going to be a growing office under this act. They will have much expanded rules and abilities to address insurance-related claims. The insurer in this case can require your explanation as to why treatments are not usually associated, etc. Providers can appeal a determination, and a healthcare provider may make a claim and assert a direct cause of action against an insurer to recover overdue benefits. The utilization reviews, so they are still there, they're going to be obviously changed underneath the new No Fault Act.
Another big change in the statute is how PIP benefits are determined to be overdue, and a tolling provision for the 1 year back rule was included in the statute. So essentially, the most simplified way to state it is that if a bill is not submitted to the insurer within 90 days after the date that the service or the product was provided, the insurer has 60 additional days on top of the 30 days that they would normally have under the Act to pay the benefits before they're considered overdue. So essentially, if you don't get a bill within 90 days of the date of service, you get 90 days to process it for whether or not it will be paid. The 1 year back rule is tolled from the date of a specific claim for payment until the date the insurer formally denies the claim. And so that's important because normally we know we have the 1 year back rule. Essentially, you can count back a year from the date that a claim was filed. But here we have two requirements. It's told from the date when the claim was made for a specific claim for benefits, and it's told until the date the insurer formally denies the claim. And so we don't know what formally denies the claim means yet. Obviously, we're always best served by putting things in writing, and we can talk more about best practices as this kind of progresses over the next year, and we do some additional webinars. But the important thing to know right now is that the 1 year back rule now has a tolling period for when the insured makes the claim through the time that it's formally denied. The caveat to that is that if the person making the claim fails to pursue it with reasonable diligence, there is no tolling period. A lot of litigation is probably going to come up as to what is reasonable diligence in that time period.
Yes, as Renee said, we go back in time for people who have handled claims long ago in a far, far away land. Oh, that was Michigan. Yes, there was tolling, and we did have some cases that dealt with what is a formal denial. So I'm sure we'll go back to try and use those, but that was all across the board. We had different Court of Appeals decisions, and now we will await the new Court of Appeals decisions once they came out to define what these terms mean under the No Fault Act. So yes, even though this wonderful act has been around since 1973, we are still litigating things about it, as you well know, into 2019. Can you just imagine what this new act will bring in the amount of litigation and what each term or each word will mean? I'm sure we'll create a whole new body of law in the years to come. Attorneys, liens, and attorneys' fees. This is a very large issue that has many of the plaintiff bar up in arms because they used to be able to claim a lien for payment of attorney fees. However, it's now been changed that they cannot claim an attorney fee lien unless a payment for claim is authorized under the Act and it must occur with the and a payment for the claim is overdue under the Act. This takes out those aspects of attending care that where someone claims ongoing attending care and the insurer is voluntarily making them and the attorney continues to take it for years and years to occur. Obviously, the legislature heard some significant issues with this and they've addressed it. A court may award an insurer a reasonable attorney fee just as they could now under 3148. However, this has been changed against a claimant's attorney for defending against a claim for which a client was solicited by the attorney in violation of the laws of Michigan or the Michigan rules of professional conduct. Again, I'm sure this area is going to have some interpretation and require some legal wrangling if an insurer will go after a plaintiff attorney for a fee. But this is now a new area that's going to be available to insurers.
The legislature did a few things to ensure that some of the issues the insurance industry has had for a long time with plaintiffs' attorneys working with certain healthcare facilities and then both obtaining a fee on both sides of that. The legislature addressed that by including a portion of the No Fault Act to state that a court may not award an attorney fee to an attorney for advising or representing an injured person for PIP benefits if the attorney or a related person of the attorney has or had at the time of treatment a direct or indirect financial interest in the person that provided the treatment. So this is trying to quash some of the relationships that we see between the medical providers and the plaintiff's bar, where they're both making money off of the treatment facilities that may be owned by themselves or maybe owned by some relative, in an effort to hide those relationships.
Now we have new IME rules. These IME rules really, they initially at first blush may have some teeth, but when you look at them, they really are not anything that we are not operating under currently. First, the IME doctor must specialize in the same specialty as the physician providing care to the person being examined. That means if you're going to have a chiropractor, you're going to need a chiropractor. You're not going to be able to use a phys med doctor to get in that area unless he's also has chiropractic training. If the physician providing the care to the person is board certified, the IME doctor must also be board certified. So you must match. However, when you do an IME and you schedule an IME, the qualifications for the IME doctor are simply that they have to be in the same specialty as a treating doctor, if any, and they also have to be board certified or board eligible. Board eligible is a very wide open criteria, which means you just have met the qualifications. Doesn't mean they have to pass a board certification. So you still have many doctors that are available to you for your IME aspects. The instruction of students in an accredited medical school or residency is also included in the active clinical practice of medicine, rather than just actually having their own active practice.
Yeah, so essentially we've seen a lot of pushback from the plaintiff's bar as to IME doctors who are being used, that basically all they do is IMEs, which is not a best practice for us anyway, but in the event that you have an IME doctor that you're using, you've got to make sure that they've devoted a majority of their professional time in the last year before the examination to either the active clinical practice of medicine in that specific specialty that Nate talked about with the treating doctor, and then as Nate mentioned, also the instruction of students will count towards that professional time analysis.
Obviously, this is going to be key for you because you don't want the doctor to get struck later on. So this is some area that you're going to need to be able to call some of the doctors that you use, as there are several IME doctors that sometimes have stopped practicing and just come in on a regular basis just to do IMEs or just to see patients on occasion. We're going to have to steer away from that and then get into more active treating doctors, which we already believe in. Tort liability. This is now for your BI adjusters. Everyone has now been opted into a $250,000, $500,000 when the new policies come out in July. That is what they're going to be placed in. They will be able to opt out of the $250,000, $500,000 limit to go down to a lower limit. The limit has been raised to a minimum of $50,000, $100,000. However, you must immediately be placed into $250,000, $500,000 by your agent or whenever you get a policy. If you'd like to opt out and go to a lower limit, you have to fill out a form that's going to be created by DIFS. Again, imagine that. And then you'll be able to look at that and then be counseled as to why higher limits would be more appropriate. And the main reason that higher limits will be sold is due to the fact that anything not recoverable in PIP once you reach the limit is now recoverable in the BI case. Therefore, you will now have personal liability for these PIP claims that used to be barred, and you could only claim pain and suffering. Now you will have pain and suffering and anything that is in excess of the PIP limit for the individual. There's no damage limit for tort auto negligence claim involving persons who opted out of no-fault coverage. So you can see some significant changes in the tort liability aspect that are incurring, and I'm sure Renee is going to talk about the threshold coming up.
Yeah. Before we move on, though, I do want to kind of point out that not only are we talking about damages in excess of the applicable PIP limit that you may choose, whether it's $250,000 or $500,000, but the statute specifically states that you can also make claims for damages in excess of the daily statutory, monthly statutory, and 3-year statutory limits, which we, if you think of it in the context of, for example, replacement service is $20 a day, does that mean that replacement services can be claimed in excess of that? maybe another $20 a day or something presented to a jury. That's yet to be seen, but it reads that way.
As well as the attendant care issue. They can claim more than the 56 hours per week. That is going to highly drive the BI cases.
And as Nate was talking about, the coverage statutory minimum increased from the 2040 to a 5100 if that insured makes a informed decision about that, essentially. But the kind of statutory minimum that you will all be signed into will be $250,000 and $500,000 limits, unless you opt for the 50-100 coverage and make a specific selection and make an informed decision on that form created by DIFS, indicating you understand that there's a lot of risk associated with selecting those lower limits.
It's going to make it more difficult for people to get the policies online also, because they're going to have to go through all these different clicks and then maybe have some type of video that they have to watch. So the insurers that do most of their work online, this is going to be more difficult for you to be able to sell the policies and to have people lower than 250, 500. So that's going to be one difficulty with that I foresee with these issues.
The McCormick threshold, we're all familiar with it. Anyone doing the BI auto negligence claims, we understand the serious impairment threshold as defined by McCormick and the No Fault Act. Those more detailed instructions from McCormick have been codified. So the serious impairment threshold, objectively manifested impairment of an important body function, affecting the injured person's general ability to lead their normal life, all of that language from McCormick has now been codified and is made into a statute and defined. So objectively manifested is defined as observable or perceivable from actual symptoms or conditions by someone other than the injured person. Impairment of an important body function is a body function of great value, significance, or consequence to the injured person. And if it affects their general ability to lead their normal life, is whether it's had an influence on some of their capacity to live in her normal manner of living. But there's no requirement as to how long an impairment must last. It's simply fact and circumstance specific, case by case, and it does codify the requirement that we have to compare a person's life before and after the accident to make this determination.
Mini tort has also been increased to $3,000, which is pretty significant, as I'm sure it's going to affect the collision coverages that people take and that the insurers are offering. This may also increase some type of small claims litigation that the insurers may want to contest. However, that's going to be wait to be seen. However, the limit currently obviously is very small at $1,000, so increasing it to $3,000 will trying to hopefully lower some limits and lower the insurance rates for some people by increasing their exposure that they are willing to accept.
We want to go back to talking about PIP, and specifically we're going to talk about the Michigan Automobile Insurance Placement Facility, or assigned claims, and we're also going to talk about the MCCA and anybody handling CAT claims through them. The changes for the assigned claims were pretty significant, but a lot of them have to deal with how the assigned claims facility processes these claims. So anyone making a claim through assigned claims has to provide an application and reasonable proof of loss to the MAIPF. The MAIPF has to specify in writing what materials constitute reasonable proof of loss within 60 days of application, which for me starts to raise the question. We're always arguing about what is reasonable proof for a claim. If the MAIPF starts accepting reasonable proof or putting in writing what is reasonable proof for us, how does that affect claims that are not assigned claims? How is that going to be used by the plaintiff's bar to support their position that they have submitted reasonable proof if an insurer is saying it's not enough? That's yet to be seen, and it will play out as these claims come in. Another change is that interest is not required to be paid in connection with an assigned claim by an insurer for any period of time during which the claim is reasonably in dispute. What does reasonably in dispute mean? That's going to be litigated. The assigned claims facility has to be put on notice of the claim within 1 year of the accident. The limits to benefits are $250,000 or $2 million, depending on certain circumstances that are specified in the Act. The assigned claims facility may require an examination under oath with 21 days notice, and a bunch of other kind of requirements as to how those things are scheduled, where they're scheduled. Those are put right in the statute. The statute of limitations for indemnity or reimbursement for assigned claims is that it must be commenced within 2 years of the assignment of the claim to the insurer, or 1 year after the date of the last payment to the claimant, whichever is later. And then finally, assigned claims may seek attorney fees from the owner or registrant of an insured vehicle. This has all become codified.
One interesting aspect is that it does codify that the examination under oath is now codified. So, since that is codified for MAIPF, does that mean, since it's not been stated in the Act, that another insurer cannot have an EUO in a PIP case? To be seen, but that is something that will probably be argued against the ability to take an examination under oath in a PIP case. The MCCA, everyone knows the wonderful MCCA. The reform bill provides for the significant oversight of the MCCA. They will now begin having every 3 years an audit. The report of findings are going to be provided to the legislature. If an actuarial examination shows assets of the MCCA exceeded 120% of its liabilities, time for a refund. That is going to be what's going to happen. The members then must distribute the refunds to the insureds. Clearly, the legislature wanted to make the MCCA more transparent and have the ability to address them and look at them more closely underneath the new No-Fault Act.
And in keeping with that decision by the legislature to have some more oversight as to the MCCA, there are a lot of new requirements for the MCCA to keep the legislature informed and keep the public informed as to the claims that are open in any given year, the amount expended on the claims, future anticipated costs of the claims, and they've got to send a historical data report as to closed claims, the length of open claims, to the legislature as well. As we already talked about, there's going to be an independent actuary review done every 10 years, and those findings are to be provided to the legislature.
The MCCA retention has been increased for policies renewed before July 2nd, 2020, and for policies after, with the unlimited medical option, is now $580,000 set. That will be it. The only persons who select unlimited will be required to pay the MCCA fee after July 2020. The anti-fraud unit is now going to be enacted under Chapter 63 of the Insurance Code. That is going to be an entirely new chapter. It establishes a anti-fraud unit as a criminal justice agency within the DIFS again. It allows the anti-fraud unit to conduct criminal background checks on applicants for licenses and current licenses. It allows the director to share and receive certain documents, materials, and information, and requires the anti-fraud unit to prepare and publish to the legislature beginning July 1st after 2020 a report on the anti-fraud unit's efforts to prevent automobile fraud. Well, we've reached the end. We have some other issues. Section 3112 in the Act, it says the bill would apply to products, services, or accommodations provided after the bill's effective date. So, there are some issues as to when all this will go into effect and the effect it will have on current pending claims and the need going forward. We are hopefully going to address this in 2 different segments. We're going to have some different webinars coming up regarding the effect just on PIP, and then breaking it out also the effect on the BI aspect. So look for those. If you have any great questions, anything that you need, please feel free to contact myself or Renee at our information attached. Our phone numbers are there for you. Anyone in the office here will be up to date and be able to debate this with you and to try to answer your questions that you are going to have, because this is going to be an ongoing issue. Renee?
If there are any claims departments or PIP departments that would like for us to come in and answer questions or do a presentation as to any specific topics, or just go over this presentation again, we're more than happy to come in and do that. Just contact Nate or I and we'll get that set up. We can also do a presentation as to best practices to make sure that we're complying with the new rules under the No-Fault Act. And just as a final reminder, as we're recording this, it's May 29th. Governor Whitmer has yet to sign the bill into law, but it's completely universally expected that she will sign it into law this week, as it's been passed as kind of a bipartisan deal by the Michigan legislature. And
just remember, the last act was done in 1972-73. this act is going to have plenty of different changes and interpretations. Please feel free to know that different opinions will occur, and hopefully we'll get you to the right opinion.
All right, thank you for joining us. Again, give us a call with any questions or comments.
Have a good day.